Hi, this is Steve Franks, the CEO for your Washington Realtors. As you know, our industry is driven by paperwork. Every transaction comes with a set of forms and a set of addenda, and it can get pretty thick after a while. So to help us with that, we have our own real estate attorney, Annie Fitzsimmons, who is our legal hotline lawyer for your Washington Realtors. And Annie is joining us today to tell you a little bit about one aspect of the form. So let's hear from Annie Fitzsimmons.
Certainly each and every one of you are familiar with Form 21, the Purchase and Sale Agreement, the statewide forms Purchase and Sale Agreement. When you complete the buyer's name on line 2, you aren't very far into the transaction yet or into the buyer's offer, but it's an absolutely critical line to complete properly. You have an opportunity when identifying the buyer to identify the buyer with simply the buyer's name and nothing more, or to include at the end of the buyer's name the phrase and/or assigns. In most cases, the addition of and/or assigns may be wholly irrelevant to either party. In some transactions, however, it has an enormous effect. The addition of those three words, and/or assigns, gives the buyer the ability to assign their right to purchase the property to any other buyer prior to closing without consent from seller. Now, in most transactions, if the seller is receiving an all-cash purchase price at closing, even if it's from the proceeds of a buyer's financing, it's still an all-cash proceeds to seller. In most cases, with that outcome, seller's not going to care who the buyer is. But if the buyer's offer contains a component of seller financing, then the identity of the buyer who closes a transaction is absolutely critical to the seller. And the seller needs to verify the actual buyer's financing credentials. For that reason, in a seller financing transaction, the and/or assigns language should never be allowed to remain as part of the agreement between buyer and seller following seller's review. In other words, if the offer comes in with and/or assigns language on paragraph 2, listing broker needs to make sure that language is eliminated from the agreement before the seller agrees. Similarly, if seller has provided listing broker with the instruction that under no circumstances will seller sell to fill in the blank. Perhaps it's a business competitor if commercial property is being sold. Perhaps it's an ex-spouse when residential property is being sold. It could be any number of folks. It could be the next door neighbor who's been at constant war with the seller the whole time they've owned the property. Doesn't matter what the seller's reason is, as long as they're not violating the fair housing laws, of course, with their instruction. If the seller gives an instruction to the listing broker that under no circumstances will the seller sell to a particular buyer, then listing broker, your radar needs to go up at that point because you need to be critically aware of who the buyer is that's going to close a transaction. A straw buyer could make the offer, a person who is not the person that the seller has forbidden in his own mind from purchasing the property. That straw buyer, however, could assign their right to purchase the property to the person that is to whom the seller would object as the buyer at closing. There's plenty of good reasons for a buyer to want to use an and/or assigns provision that have nothing to do with the seller at all. Buyer may intend to create an LLC and transfer the buyer's right to purchase the property into an LLC prior to closing. They want to buy the property now and tie it up, but they don't have their LLC created yet. So they purchase as an individual or as a person and/or assigns, knowing that they're going to transfer into their LLC. It could be that buyer husband is in town and buyer wife is not, and buyer husband doesn't have a power of attorney for buyer wife. Buyer husband wants to secure the property and writes the agreement as buyer husband and/or assigns, knowing that he will assign his interest to purchase the property to his marital community prior to closing. All of those are very legitimate and very good reasons for using the and/or assigns provision. Just because a listing broker receives an and/or assigns provision doesn't mean that buyer's trying to get away with something. And in fact, even if the and/or assigns is eliminated from the transaction, it doesn't mean that buyers can't still assign buyer's interest in the transaction. It simply means that buyer would have to have seller's consent in order to assign buyer's interest in the transaction. So if you have a situation where there's some tension on seller's part about whether or not the assignment will be appropriate in seller's circumstances, eliminate the and/or assigns provision. And then when buyer needs to assign to their marital community or to the LLC that they've created, which would be wholly harmless in the seller's mind, likely, then seller will hopefully consent to that assignment. It's important that you understand all of the nuances of the statewide forms. This is one that seems very small, but as you can see, could have huge impacts on the transaction. Thanks for listening. If you have questions about what we just discussed or anything else, make sure that you send me an email at legalhotline@warealtor.org. Thanks.